Good morning, Remax Distinctive. It's Dan Bouchard with today's July update for the broker update for Washington, D.C. We're going to discuss D.C.'s fair housing, which includes definitions that are also included in the federal law. So what we're going to talk about specifically is identified in the link above. In the handout, you'll be able to find that the language and the links for this link for the DC Office of Human Rights and the source of this information that we're discussing today located at that link. All right, age, and that's our first topic. So long as a party is of legal age to make a legally binding agreement, we may not use their chronological age against them. So this is a vital importance. As long as they're of chronological age and legally able to make their decisions, we can't use their age. Now, this goes hand in hand. This discussion goes hand in hand with matriculation and family responsibilities, and we'll talk about those in a little bit later on in this lesson. But I wanted to make sure that you understand that that age plays a role in the matriculation and the family responsibilities section. So just be aware of that. Color is to be identified, and I use the example on a personal level, and you can apply this to how whatever filling in the descriptors as you need to, whether it's somebody that's darkly complected or light complected or more shades of white or pink versus more shades of brown or maroon or various grades of coloration here here and there. That's really what we're talking about. I may have a skin color appearance of pasty white with a hint of flesh pink hues with limited tanning ability before I burn. And that may be the way that I am. Whereas my cousin has a more pasty color, lots of freckles with red hair, and can spend zero time in the sun before burning. You can change any of these descriptors to fit any skin color descriptions. The same result applies. If I'm going to be discriminating on how shaded I am or how colored I am or the lack of coloration in my skin or hair, then that fits into color discrimination. Credit information. Self-explanatory, except that in DC, you can't make any decisions based on credit scores. Only the content of the credit report can be used as credit denying author's ability when particularly we're talking about tenants. It really doesn't really apply. Now we also can't discriminate against tenants, excuse me, against buyers who have poor credit information, except wherein if they are simply not qualified for the loan, then that's not our decision to make. It is a lender's decision to make. So you can require that a tenant be pre-approved before you can require that a buyer be pre-approved before starting to work with them, but you can't make that determination on your own. You have to simply say, are you pre-approved with a lender? If not, let me get you hooked up with a lender or let me refer you to several lenders and then once you have that pre-approval in hand, then we can start talking. But you can't use their credit information as a reason to not work with them. So be careful about how you're maneuvering through this. Make sure you're not making this decision. You're putting the onus on your mortgage lenders to make those decisions for you to qualify them. If you start getting involved in qualifying people for their credit based on their credit, you're risking the chance of you having number three held against you in violation of DC laws and any alleged claim or allegation that you violated somebody's rights and is probably going to result in monetary penalties against you unless you can absolutely fundamentally prove that it was not the case. So DC takes this stuff really seriously. If an allegation comes to you through the Office of Human Rights, and a tenant complains to the DC Office of Human Rights that you had violated any of these criteria, you're probably going to face an attorney on the other side who is going to represent the tenant, the buyer or the tenant, whichever the case may be. And chances are you're probably going to you're going to lose money, and or worse if you have violated these laws. So don't play around with this. If you have any further questions on it, please give me a call, and let's discuss it more. You can only discriminate based on the content of their credit reports. You can't make any credit score decisions. You can't tell them, I won't work with you because you don't have a credit score of 600 or 580 or 700, whatever. You can't use those kinds of descriptors. And you shouldn't be involved as a real estate licensee in determining that. You should be relying on another entity to provide that qualification for you. Disability, any major life functions, if it can be attributed to physical, psychiatric, psychological, neurological impairment, it applies. So hearing applies, ADHD might apply, um, um, any learning disabilities could apply. Anything that diminishes the person's ability for a major life function qualifies. And if you are venturing into the gray area, and everything I teach is always about staying away from the gray area, because 9 times out of 10, when you're working around the protected classes, especially in Washington, D.C., operating it within the gray area is what is going to get you a violation. Oftentimes, we are not held liable. Oftentimes, we don't face complaints for blatant violations because we know enough to stay away from them. Oftentimes, the most common cause of a complaint against you is because you have ventured into the gray area, and that's where agents get caught up and end up having to pay fines, penalties, or damages to a complainant. So again, that's where we are. Family responsibilities. The anticipation or existence of children in the home. It's plain and simple. That is what it is. Whether somebody is planning on having children, whether they are in the process of adoption, whether they actually do have children or not, whether they're taking care of those children or grandchildren, and even parental responsibilities fall into that, especially if you have legal rights for being an elderly parent or a parent who is deemed not competent to be their own guardian. If you've been designated that way by the courts, we cannot have any take any adverse reactions against that tenant or the buyer for that purpose. Famil Familial status, whether there are children or planned, anticipated, or a declaration by the tenant that they are opposed and very intermixed with the qualifications of these classes. So make sure that that you are not venturing into any kind of gray area. If you're venturing into the gray area, then let me know and we can further discuss it. But for the most part, you really don't want to be venturing into any kind of gray area and certainly not into any direct violation of these things. Gender identity and expression. DC law recognizes and protects the consumer's right to express themselves in any way they choose. Whether you disagree with it or not, whether you have objections to it, whether you have a religious view about that or not, that's irrelevant. We have an obligation by the letter of the law in the District of Columbia to accept the way that the tenant or the buyer, or the seller for that matter, seller and landlord for that matter, choose to participate in them, to whether however they choose to identify their gender is acceptable, and we must not discriminate against it. A religious belief affects our own ability and our own conduct in our lives, but it does not impose us on to others our religious views. So we have to serve equally everybody who comes to us and wants to have services from us and must treat them equally, regardless of how they express themselves in their gender identity or expression. Genetic information typically does not apply to housing, but could if the information ever became known. This is one of the protected classes. There are 23 protected classes in the District of Columbia. This is one of them that is not a protected class for housing, only because it is not usually made known or available. We would usually wouldn't have this genetic information um, delivered to us in the course of working with a buyer, seller, landlord, or tenant. Now, if you happen to have that information, you can't use that information against them. Just because it doesn't say housing in here doesn't mean you can't be held liable for it, because it is specifically prohibited to act on genetic information. And so if you happen to get, if the buyer, tenant, landlord, seller happens to disclose to you that they have some kind of genetic condition, then you can't use that against them. Homeless status. The definition of an individual, family, or youth who lacks or lost or will eminently lose a fixed, regular, or adequate nighttime residence, which can include the result of escaping an unsafe environment. So, homeless status is very broad, it's very expansive, and it also goes into a couple of other protected classes that are intermingled with it, like appearance. Personal appearance is one of them. We're going to talk about that in a little bit. But for now, understand that if somebody appears to be homeless, or looks like they're homeless, or acts like they're homeless, or acts like they are maybe have a disability because and is tied to their homelessness. If it seems to you like they are homeless, you can't use that as any justification to deny them service, or to deny them a rent or a sale in the transaction. You can't use it as a condition. So we're going to stop our conversation for today, and we will jump on the rest of them next month as we move forward and finish up with the rest of these protected classes. Thanks. Take care.